This presentation is on 2 YouTubes, each approximately 10 minutes in length. Today I would like to voice my opinion that Oregon's judicial system is run by many arrogant, ignorant, incompetent, negligent, and corrupt lawyers and judges. Am I making vicious and unfounded statements, or is my opinion supported by facts? Let's look at some facts so you Oregon tax-paying citizens can make your own informed decision. Keith McMullin has already spent over 4 years in prison for a crime he did not commit. He was framed by the Clackamas County District Attorney's Office with the support of Judge Jeffrey Jones. McMullin was charged with the rape, penile penetration of a petite 11 to 13-year-old girl 2 to 3 times per week for 18 months. On examination within a few days of the last alleged penetration, she was found to have a normal, intact hymen, a medical impossibility. Any qualified family doctor or OB/GYN specialist could and would so testify or risk the suspension of their license to continue examining female patients. Instead, the state called a nurse practitioner, Christine Smith, as their expert witness. She testified that she expected a normal exam in cases with multiple long-term sexual penetrations examined shortly after the last penetration. Heather Karabika, McMullin's court-appointed attorney, did not question Smith's false claim that she was as qualified as an MD to do her job. No questions about her training and experience doing pelvic exams. Smith claimed her opinion was based on the Kellogg study. Karabika did not question Smith about the study, nor did she introduce any of many easily available medical studies to refute Smith's perjury. She also did not call a medical expert to refute the perjury. What defense did she offer? None. In her review for the appeal board, Lindsay Detweiler, an appeals court attorney, stated that an MD had testified in the trial. Ms. Detweiler, a nurse practitioner, is not an MD. The appeal panel, consisting of 3 judges, affirmed the case based on the lies by Christine Smith, Lindsay Detweiler, and Stacy Goodman. Ellen Rosenblum, Oregon Attorney General, in consultation with lawyers in her office, also affirmed the case. All appear to feel Karabika did a good job allowing her innocent client to be framed, offering no defense. During McMullin's trial, Stacy Goodman, the prosecuting attorney, emphasized to the jury that this case had no physical evidence, so testimony was considered evidence. Judge Jones also so instructed the jury. An intact hymen is physical evidence, a fact ignored by all of the many lawyers and judges involved in this case over the last 4 years. McMullin's new appeals trial to determine that Karabika had been an inadequate counsel was held February 21st, 2017. In preparation for this trial, his new attorney, Michael Levine, requested that Karabika send all her notes and materials relating to the original trial to him, this normal procedure. She was then deposed. During this deposition, Karabika committed perjury at least twice. I'm not a lawyer, but lying under oath is perjury, is it not? Her lies should be apparent to anyone reading her deposition, even those persons without a law degree. Lie number 1. When asked why she did not obtain an expert witness to refute Smith's lie, Karabika replied that she didn't think the state would approve payment for an out-of-state medical expert. Levine then produced a copy of an email retained by McMullin, but not found in the material turned over to Levine by Karabika, which stated that McMullin's family would somehow raise the money if the state would not pay for the medical expert. Where was Karabika's copy of that email? Why did Judge Penn regard Karabika's perjury as the act of a normal, competent lawyer? number 2. When asked why she did not question Smith about the Kellogg study, Karabika stated that she was blindsided and had never heard of the study until that day at the trial. Michael Levine then questioned her about the letter she had received from Lisa Maxwell, an attorney from whom Karabika had requested advice on how to handle this case. The letter stated that she should be prepared to defend against the Kellogg study, often used in such cases by prosecutors. The letter also stated other medical studies and a qualified medical expert should be used to refute the perjury. Why did Karabika lie? Was it an act of a competent lawyer to completely ignore the advice of a more experienced attorney from whom she had solicited advice and now lie about it? Judge Penn apparently thinks so. Karabika stated that she had consulted with Dr. William Brady about the case, who she said told her he could not help her, but she paid him $1,500 of our tax dollars for him to tell her that. This case involved no DNA, fingernail scrapings, hair samples, blood, semen, or saliva. Brady is a forensic pathologist who may be expert in such matters, but is not remotely qualified to testify about pelvic exams. Why not use the $1,500 she wasted to help pay for an expert who could help McMullin's case? Does anyone think Ms. Karabika goes to a forensic pathologist for her pelvic and breast exams, or do you think she might go to her family doctor or an OB/GYN specialist? Both are specially trained and experienced to perform and evaluate a pelvic examination on which this case hinged. Might Brady have said he couldn't help her because he knew his credibility could be easily destroyed before the jury? Any competent attorney should know this without paying $1,500. Definite proof Karabika did not act as a competent attorney would. During his preparation for this new trial to determine if Karabika had been an inadequate counsel, Michael Levine pointed out 17 glaring errors in her trial performance. He obtained a nationally known medical expert, a qualified, experienced psychologist, and an experienced trial lawyer, each testifying to the many deficiencies in Karabika's conduct in preparation and performance during McMullin's trial. In addition, a peer of the accuser submitted a sworn statement in which the accuser had admitted that her dad did not rape her. Ellen Rosenblum denied the relevance of almost all the points raised and dismissed the new evidence by the 3 experts as worthless and affirmed the conviction again. Judge Penn, in this new trial, within 1 hour, rendered his verdict declaring all 17 errors in the testimony of 3 experts as irrelevant. He upheld Christine Smith's perjury and the false evidence presented to the jury by Stacy Goodman during the original trial. Judge Penn is an interesting choice to preside. Karabika served as one of his clerks early in her career. He denied remembering much about her, using Stacy Goodman's logic in the original trial, where she stated that we really don't know if there were other victims at McMullin who would now come forward. We don't really know if Judge Penn and Karabika had a previous relationship. Why did he not recuse himself so this doubt would not be a factor? Penn also did not even allow the peer of the accuser to testify, stating it was hearsay. During the original trial, all testimony by all state witnesses, except for the factual finding of the intact hymen, was hearsay. No one knew anything about this case except what the accuser had told them. Why do Judges Penn and Jones think it was okay to allow hearsay during the original trial? Do Judges Penn and Jones apply the hearsay rule only when it helps convict the innocent? Was it competent lawyering by Karabika not to object to obvious hearsay? If you think this is an isolated case, I will point out a few others that have come to my attention as I looked into this case. They span many years. I heard of a few more that I will not present. Tom Cameron was convicted of child abuse in Washington County 3 to 4 years ago. He was accused by his ex-wife of abusing his stepdaughters. He was offered a plea deal of 12 months probation with no jail time. He refused to plead guilty to a crime he did not commit. So like McMullin, he was framed by the authorities and sentenced to 25 years. Now use some common sense. What person guilty of sex abuse would be stupid enough to refuse 12 months probation with no jail time? This case smells really bad. It demands investigation. Second one, many years ago, a man was accused of abusing his 6 children by his ex-wife. He was offered no jail time for a guilty plea. On the advice of his court-appointed attorney, he took it. The attorney advised him that it was nearly impossible to win in Oregon when charged with sex abuse unless you had a lot of money to fight the case. Since that time, all 6 children have become adults, and all have now stated he never abused them. He still must register as a sex offender. The third case is really horrible. It also involves DHS, as does the McMullin case. Several years ago, a couple adopted a young girl. In her DHS file was a psychologist report stating this girl should not be placed in a home with other children. She had a diagnosis of RAD, reactive attachment disorder. DHS proceeded to allow this couple to adopt, although the young woman was in the very late stage of pregnancy. In spite of continuous therapy, the girl finally threatened to kill her 2 siblings. Putting this family through this nightmare has not been enough for DHS. They continue attempting to return this girl to their home. After she kills or severely injures her 2 young siblings, will DHS say, oops? The accuser in McMullin's case has not had a formal diagnosis of RAD, unless DHS is hiding it, as they did in the above case. However, Dr. Borg pointed out in her testimony that McMullin's accuser is a likely candidate for some type of attachment disorder. One of the prominent symptoms of an attachment disorder is lying, according to Dr. Borg. The next YouTube will delve deeper into this case. How much time is that?